Good morning. In the year 2016, our High Court, our Supreme Court, in the case of Youth Bar Association of India, issued a direction that copies of FIR should be published within 24 hours of their registration on the police websites or on the website of the state government. But no police official, no police station is doing this mandate of the Supreme Court, and the superior officers are also slept over this issue, showing utter disregard and disrespect to the Article 142, the imposed on police department. Therefore, that is a different issue. Should be so. Whenever you cross-examine the investigating officer, kindly put your question to him. Do you know Youth Bar Association Judgment AR 2016 SC 4136, or did you uploaded the FIR immediately or not? If you did not say that, so basically being an investigating officer, you always want to disrespect the Supreme Court and other courts' orders. You give a suggestion like that. But surprisingly, in this given case, AR 2023 Supreme Court 615 has given some guidelines and interpretation also. The Saurav Das versus Union of India, there they say when the public interest litigation is filed to furnish copies of final report filed under Right to Information Act, the Supreme Court. First they said under Section 74 of Indian Evidence Act, the final report is not public document. They say it is not public document. So since it is not public document, it must be considered as the private document. And the private document, if anybody wants copy of private document, you should fulfill the Section 4(1)(b) of the Right to Information Act. So they held that it is up to the department to furnish the copies of such charge sheet or not. They say this is also there. They have elicited 173 subclass 4, and I want to remind you about this reiteration of the Supreme Court judgment. 173 for after forwarding a report under this section, the officer in charge of police station shall, before the commencement of the inquiry, furnish or cause to be furnished to the accused free of cost a copy of the report forwarded under section 1. So these documents ought to have been furnished to the accused immediately filing before we need not wait for copies, summons and 207 proceedings. This is also very important. Therefore, the document mentioned under section 74 will be the public documents, and since it is not mentioned there, the all other documents except 74 all are private documents. So this is what ratio. Then they say they have dismissed the appeal filed by the public interest litigant. So these two things you should keep in mind. Number one, that the FIR should be uploaded either in the police website or in the government website within 24 hours. So if anybody fails to comply that Supreme Court order, they may be dealt by the superior officer for dereliction of duty and not obeying the command of the court. Even individual can prosecute him under relevant section for not obeying the law deliberately. And there you have to show some intention there and submit. Another one was the charge sheet. Final report is not public document, and you cannot claim as a matter of right under Right to Information Act. These two ratios are there best.